hablo. Namaskar and good morning to all. I request all the dignitaries and all the participants to please take their seats. On behalf of the High Court of Gujarat and Gujarat State Judicial Academy, I, G.J. Shah, Deputy Director, Gujarat State Judicial Academy, take it to be my privilege to very humbly welcome all the esteemed dignitaries, Honorable Mr. Justice Rajesh Bindal, Judge, Supreme Court of India, Honorable Mr. Justice Manindra Mohan Shrivastava, Chief Justice of Rajasthan High Court, Honorable Mr. Justice Suresh Kumar Kait, Chief Justice of Madhya Pradesh High Court, Honorable Mr. Justice Biren Vaishnav, Acting Chief Justice High Court of Gujarat, Honorable Mr. Justice A.Y. Kogje, Judge Gujarat High Court and President Gujarat State Judicial Academy, Honorable Mr. Justice Aniruddha Bose, former Judge Supreme Court of India and Director National Judicial Academy. I also welcome all the respected and honorable judges of the High Courts of State of Rajasthan, Maharashtra, Madhya Pradesh and Gujarat, honorable resource persons, respected invited guests, members of the registry, working under the establishment of the High Court of Gujarat, and learned Additional Advocate General Manishaben Lav Kumar Dalal, Shri Mitesh Bhai Amin, learned government pleader, learned public prosecutor, and respected participant judicial officers coming from the district judiciary from the state of Rajasthan, Maharashtra, Madhya Pradesh, and Gujarat. I welcome all to this West Zone 1 regional conference on court dockets, exclusion and exclusion, organized by the National Judicial Academy and hosted by the High Court of Gujarat and the Gujarat State Judicial Academy. Thank you all the dignitaries for gracing the dais. Before formally starting the inaugural session, let us take a moment to honor our nation. I will request everyone to rise for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Ladies and gentlemen, as a token to express our feeling of respect, I most humbly request Honorable Mr. S.D. Suthar, Registrar General High Court of Gujarat, to felicitate Honorable Mr. Justice Rajesh Bindal, Judge Supreme Court of India, with a shawl. Now I request Honorable Mr. Rohan K. Chudawala, Director, Gujarat State Judicial Academy, to felicitate Honorable Mr. Justice Manindra Mohan Srivastav, Chief Justice of Rajasthan High Court, with a shawl. Now I request Mr. V.G. Rana, Assistant Director, Gujarat State Judicial Academy, to felicitate Honorable Mr. Justice Suresh Kumar Kait, Chief Justice of Madhya Pradesh High Court, with a shawl. Now I request Ms. P.K. Dave, Assistant Director, Gujarat State Judicial Academy, to felicitate Honorable Mr. Justice Aniruddha Bose, former Judge, Supreme Court of India, and Director of National Judicial Academy. I will now request all the respected dignitaries gracing the dais to come forward and water the sapling. Thank you very much, my lord. Moving forward, I will now request Honorable my Lord Mr. Justice Biren Vaishnav, Acting Chief Justice, High Court of Gujarat, to deliver his welcome address.
Good morning, everybody. Honorable Justice Rajesh Bindal, Judge Supreme Court of India. Honorable Justice Shrivastava, Chief Justice, High Court of Rajasthan. Mr. Justice Kait, Chief Justice, Madhya Pradesh High Court. Justice Kulkarni, Judge, Mumbai High Court. My brother Justice Kogje, President of the Judicial Academy. Justice Upaya, Chairman Gujarat High Court Legal Services Committee. Dr. Justice Pushpendra Bhati, Judge High Court of Rajasthan. Dr. Justice Anita Sumant, Judge High Court of Madras. Justice Maushami Bhattacharya, High Court of Calcutta. Justice Surat Govindraj, Judge High Court of Karnataka. Mr. Justice Anup Chitkara, Judge, Punjab and Haryana. Former Chief Justice of our High Court, Justice Sonia Gokani. My brother and sister judges, Manisha Lal Kumar, the Additional Advocate General. Mr. Mitesh Amin, the Additional Advocate General. Mr. Vic, the Government Pleader. Mr. Hardik Dave, the Public Prosecutor. Officers of the Registry of the High Court, the staff members of the High Court, members of the District Judiciary, academic coordinators, Mr. Rajesh Suman, the Assistant Professor, and Dr. Smith Bhattacharya, Research Fellow, National Judicial Academy. Now comes the session. Distinguished guests and esteemed dignitaries. It is a great privilege and an honor that I extend a warm welcome to each one of you at the Regional Conference on Court Dockets, Expansion and Exclusion. This conference, organized in collaboration with the National Judicial Academy, the High Court of Gujarat, and the Gujarat State Judicial Academy, stands as a testament to our commitment to ensuring an efficient, inclusive, and progressive judicial system. Your presence enriches this conference, and we look forward to your invaluable contributions to our discussions. As we gather today, I am inspired by the profound words of Dr. Ambedkar, who once said, and I quote, "The administration of justice should be speedy, inexpensive, and accessible to all." Unquote. These words resonate deeply with the theme of our conference on court dockets, expansion, and exclusion. They serve as a timely reminder of the ideas that must guide our work within the justice system. My apologies, I forgot to name Justice Aniruddha Bose. We are privileged to have amongst us some of the most distinguished members of the judiciary who have led remarkable advancements in integrating technology into our legal framework. Honorable Mr. Justice Rajesh Bindal, during his tenure at the Punjab and Haryana High Court, disposed of approximately 80,000 cases and played a pivotal role in judicial administration. Justice Bindal, while speaking as the chief guest at one of the functions at the Allahabad University, pointed out that more than 5.2 crore cases are pending in various high courts across the country, with only 20,000 judges to oversee them, highlighting the urgent need for judicial efficiency. His Lordship, while addressing an enlightening session at the LPU School of Law, emphasizing the transformative role of information technology in the judiciary, stated, and I quote, "Technology has enabled the judiciary to tackle long-standing issues like case backlog and complex data management. It has streamlined processes and allowed greater focus on substantive legal reasoning." Unquote. His Lordship also underscored the ethical challenges posed by emerging technologies, stating, I quote, "In the coming decades, AI could become more intelligent than humans. While it is crucial in enhancing efficiency, it is equally essential to ensure that its use aligns with the principles of justice, fairness, and accountability." Unquote. Tomorrow we will have with us Honorable Mr. Justice Satish Chandra Sharma, Judge, Supreme Court of India, who has been a strong advocate of leveraging technology and alternative dispute resolution to enhance judicial efficiency and accessibility. During His Lordship's tenure as the Chief Justice of Delhi, His Lordship spearheaded several information and communication technology initiatives in modernizing court operations. He launched key projects like the secure, scalable, and Sugam website for the Delhi district courts. In addition to His Lordship's contributions in the technology-driven reforms, Justice Sharma has emphasized the growing importance of mediation in dispute resolution. Speaking at the National Conference at Mediation, His Lordship had remarked, and I quote, "The exercise of mediation is born out of societal morality as it promotes amicable resolution and reduces friction." Unquote. With this foundation, we now turn to the core theme of our conference. At the heart of our discussions over the next 2 days lies a crucial objective: to explore ways to enhance inclusivity, optimize court docket management, and embrace emerging technologies in the justice delivery system. The 2-day conference will encompass 5 key sessions addressing crucial aspects of the legal and judicial system. we will begin by discussing strategies to enhance inclusivity and optimize court management while addressing docket exclusion and reducing case backlog. This will be followed by an exploration of e-court initiatives and their role in bridging the digital divide to promote accessible judicial services. The conference will then shift its focus to the effectiveness of alternative dispute resolution mechanisms, particularly online dispute resolution, in ensuring swift and efficient justice. On the second day, we'll analyze the interplay between the judiciary and the media, critically examining the influence of social media on legal landscape. Lastly, we will delve into the future of judicial governance, the transformative role of artificial intelligence in the decision-making processes. Participants' feedback will also be gathered to foster continuous improvement in our pursuit to justice. The explosion of court dockets is not just a crisis in numbers, but a deeper issue of exclusion where justice delayed becomes justice denied, especially for the marginalized. An overburdened judiciary, procedural rigidity, and economic barriers often push vulnerable individuals to the fringes, making legal redress a privilege rather than a right. While the wealthy can afford privileged, prolonged litigation, the disadvantaged are trapped in a cycle of delay and inaccessibility. To counter this, courts must not only streamline case management with AI-driven triage systems but also reimagine justice delivery. Mobile courts in unreserved areas, crowdsourced legal aid platforms, and blockchain-backed dispute resolutions could become parallel pathways to justice. By blending technology with radical inclusivity, the legal system can transform from a bottlenecked institution into a dynamic force for equitable justice. The Gujarat High Court, leading in this transformation, has become the first in the country to implement digital hybrid family courts with remote adjudication taluka court complexes. This pioneering technology-driven initiative brings justice closer to the people, ensuring seamless access to the litigants and advocates. The Gujarat High Court has also launched 5 remote adjudication centers to address check dishonor cases. These courts optimize judicial resources to tackle uneven case distribution. By leveraging technology like video conferencing, these courts efficiently handle caseloads within the existing infrastructure. The themes we will deliver upon: access to justice, alternative dispute resolution, e-courts, judicial governance through technology, and interplay between judiciary and media are not just relevant but imperative in today's evolving legal landscape. I encourage each one of you to actively engage in these discussions, bring forth innovative ideas, and collectively work towards a more accessible and robust judicial system. I once again extend my sincere gratitude to all our esteemed guests for taking out the time to be part of this significant event. May this conference be a platform for insightful deliberations, meaningful exchanges, and exchangeable solutions. Thank you.
Thank you very much, my lord. I will now request Honorable Mr. Justice Aniruddha Bose, former Judge, Supreme Court of India and Director of National Judicial Academy, to give an introductory speech.
A very good morning to you all, and in particular, Justice Bindal, Justice Rajesh Bindal, who has been helping the academy whenever we request for his help. Chief Justice Manindra Mohan Shrivastava, Chief Justice of Rajasthan High Court, Honorable Mr. Justice Suresh Kumar Kait, Chief Justice Madhya Pradesh High Court, within whose jurisdiction the National Judicial Academy is situated. Honorable Justice Biren Vaishnav, the Acting Chief Justice of High Court of Gujarat, Honorable Justice A.Y. Kogje, Judge, Gujarat High Court, and all the other dignitaries who are present here. There are many, so I am not individually taking their names. Excuse me for that. And the theme has been succinctly explained by my preceding speaker, and also what we intend to discuss in course of these 2 days. This is, it's a catchline. Court dockets explosion and exclusion is a kind of linguistic euphemism. It essentially means how to deal with delay and provide access to justice. Now, Honorable Acting Chief Justice has already explained what we are going to discuss, so I'll avoid repetition of that, and that's exactly what my written speech had written, what His Lordship has said. But why have we gathered here? Essentially to deliberate on these things, and from the platform of National Judicial Academy, we need advice and suggestions from all those present in this meet. And we have developed this practice of taking the National Judicial Academy to individual states, so that we have 1.5 days with honorable judges at the High Court and district level also, for mainly exchange of ideas. Though it's called an academy, our job is not to train. All of you who come there are holding senior positions in the judiciary. Our job is to learn and share. And so more honorable judges are there or here. Our learning process gets expedited. This is of seminal importance, the timely justice. One reason is, I think 25-30 years back, the predecessors, who were also great judges, they didn't have something called NJDG, which reminded them each day how many cases are lying in his own docket and how many cases his or her High Court had to deal with. So this is a new challenge which has kind of evolved in course of maybe last 10 to 15 years. And I shouldn't speak too early, but the results are showing. The legitimacy of courts depend on the perception that the courts are fair, impartial, and accessible to all. And this trust is built through transparency, efficiency, and the ability of the judiciary to adapt to evolving social needs. The very fact that still so many people are coming to court now is a testimony that the people still repose trust and faith in the judiciary. But can all come to the court, whoever has a grievance? Ideally, there are other dispute resolution layers in society. And one reason why so many people are coming to court, in my view, is that the whole dispute is being seen by a citizen as a citizen and individual and state in that context. Earlier, there used to be family, there used to be community, then the village elders or local elders. Now all those layers have been dismantled. So people straight come to court. But here I'll quote one Irish judge. I haven't verified whether he actually said it so or not. On about access to justice. He said, justice is open to all, like the Ritz Hotel, that anyone can go in there. I'm proud to say that the courts in India are not akin to a five-star hotel anymore. You open the Indian appeals or early reports, any law reports, who are the litigants? Barring criminal cases, the litigants are big landlords, business houses, and it's not that through them law has not evolved. But now there's a chance of the law evolving also through Nilavati Vera, Sebastian Hongre. I'm talking about the early days of my legal career, and these are the cases which had inspired I think a whole new generation. Last year, I think again the NJDG data shows about 37 lakh civil cases were instituted and little over 2 crore criminal cases were initiated. In the same year, about 39 lakh civil cases were disposed of, whereas 1 crore 95 lakh criminal cases got resolved. We have about 20,000 judges now, all of us whom have overworked around the year to bring at par the institution and disposal rates. So now this is what I was terming as results have begun to show. Hopefully, this trend will continue. To address the issue of timely and efficacious dispensation of justice, we have undertaken several measures, we meaning collectively the legal community, which include promotion of alternative dispute resolution mechanisms and the integration of technology in court process, promotion of legal aid system. There is a wrong perception gathering in the minds of some people that arbitration fora is like a Ritz hotel. But this is a misconception, since we have made ADR part and parcel of our justice delivery system through wide network of block level services, legal services authorities, and court prompted mediation. ADR mechanisms in the form of arbitration, conciliation, mediation, and lok adalats have promoted as a cost and time effective mechanism to encourage settlement of disputes, to ensure quick and responsive justice to the common man. In an era dominated by rapid information dissemination, media coverage of court proceedings plays a significant role in shaping public perception of the judiciary. And there, I would say, little bit of slanted reporting is done, because none of the reports highlight how many cases are disposed of, only how many cases are pending. And the day a case is born, it goes to the pending list, which is a little unscientific way of counting or computing pendency. But accurate and responsible reporting enhances transparency, reinforces judicial accountability, and educates the public on legal matters. However, sensationalized or misleading reports can erode trust, misrepresent judicial decisions, and place, and I hope it doesn't place, undue pressure on judges. Excessive media coverage, particularly in high-profile cases, seeks to create some kind of external pressures on the outcome of a case. Like there was a film titled "Who Killed X?" But it is not the judiciary's due to find out who killed X. The duty of the judiciary is to find out whether Y, who's been arraigned as an accused, has killed X or not. So the film was wholly misdirected in its approach so far as judges are concerned. But we have to show also, we have to develop thick skin and show a great restraint. Here I have an English example. There was a spy catcher case where ex-M15 agent, he was disclosing all his work experience in a book that was called Spy Catcher. So in spite of this book being published by in various common law jurisdictions, the English courts prohibited publication about the trial. So a tabloid newspaper in England, they used the caption "You fools" and show three honorable law lords upside down in that tabloid page. That time, one of our, but the English judges declined to hold it to be a contempt. One of our very senior counsel, who is no more, who happened to be in England that time, had asked one of the judges, Lord Templeman, who was a senior judge and also whose kind of caricature was shown upside down, why no contempt proceeding was initiated. Lord Templeman had remarked that even though he believed that he was not a fool, the others were entitled to have their opinion. And that judges in England did not take notice of personal insults. Of course, not of course, I mean, we are meant to have, though I am not a judge anymore, but I'll still use this pronoun we. We are meant to have nerves of steel to wither off thunder, lightning, or rain in course of discharge of our duties. One area which we need to remind ourselves is that much of our judiciary's performance is measured in numbers. That's another problem. While statistics is necessary, I am reminded of a well-known eminent cricket writer in England, Neville Carders. I think he was given a knighthood, Sir Neville Carders. He commented about an innings. There ought to be some other means of reckoning quality in this, the best and loveliest of games. The scoreboard is an ass. It does not allow for the wind and the sun, the light and shade, the shifting accents and patterns of a day's cricket. I can say for my personal experience that while from the beginning of my judging days, I had received advice to dispose of cases, but barring one or two, no senior judge told me that you should write your judgment well. So the quality of judgment is also a very important factor in our work, and with this kind of overpresence of statistics, we are tending to ignore that aspect of our seminal duty. Now, our judgments are cited in different courts of the world, and this factor casts a duty on Indian judges to develop and evolve jurisprudence through new causes of action. As an example, once I met an Indonesian judge, and he suddenly inquired from me, how are you progressing in that case on the right to food? This is one of the lesser reported cases which the Supreme Court is handling, but this is one of the first cases on entitlement rights which we are enforcing in India. We have already evolved PIL, which I'll say is the contribution of Indian judiciary to the global jurisprudence. And if I'm wrong, kindly correct me. Possibly in Gujarat only the first letter petition was accepted as a PIL. Was it Justice Thakkar or yes? No, Justice Bhagwati, he used in Supreme Court, but here also one case was letter petition was instituted. Then in Bhopal, the interim compensation is in tort action. That was also a path-breaking decision. Apart from meeting the aspirations of the litigants for disposal of his or her cause within a reasonable time, a litigant is also interested in getting the right judgment, and the legal community is collectively interested in getting a judgment which will usher in a new theory into our legal system. Again, here I'll quote an English judge, Lord Radcliffe. He had commented, "There was never a more sterile controversy than that upon the question whether a judge makes law. Of course he does. Judges are always making law. Our system all along has been engaged in the exercise of making the law within our limits. And while reaching out to the persons in the queue in the docket, and also those struggling to enter the Ritz Hotel euphemistically, we should not forget our basic duty to give our jurisprudence a new cause of action." The discussion In the 5 sessions in this conference, we'll focus on all these crucial issues that contribute to enhancing public trust and confidence in the judiciary. Again, when I began my practice, the legal report used to come in page 5 or something, one small column by a legal correspondent. But now it has moved from the periphery to the center stage of news dissemination. That again puts an additional duty and obligation on us. With these words, I again welcome the honorable resource persons, participants, and other dignitaries to this conference. And I also, we are a co-host, thank the Gujarat High Court and the Judicial Academy for organizing this wonderful program and for creating enough comfort for us while spending these 2 days so that our brain can fully devote to what we are supposed to discuss. Thank you very much.
Thank you very much, my lord. I will now request Honorable Mr. Justice Rajesh Bindal, Judge, Supreme Court of India, to give an inaugural address.
Very good morning, my sister and brother judges, honored of the dais, dear judicial officers, ladies and gentlemen. First of all, I can share that today is a little special day for me because yesterday I completed 19 years of service, and because 22nd March was my day on which I had taken oath in 2006. Long journey. The way we have grown up in the system, I think we also learned like these programs. The only thing is that we need to take little seriously, not only that this is a holiday. That will make little change. Now, when you are a last speaker in a program and you have your senior colleagues or colleagues speaking on that and taking all the issues, touching all the issues, then sitting in a bench, we always say, I agree. Otherwise, also because I am the third one, so I can't, even if I say I don't agree, then no value. But in any case, all issues have been touched. But I think the most important part, as has been touched by Brother Bose, is the entire thing is, you see, revolving on the public trust and confidence. That we need to maintain at all cost. Our idea is to proceed in that manner. This program is being held at Ahmedabad. Our Mahatma Gandhi belonged to this place. We have Sabarmati Ashram. What we learn, peace of mind. He coolest person, maybe one of them. And in this profession also, we need our mind to be very cool. As has been touched, that media trial and all that, because these things certainly have some pressure on the mind. But still, we have to think and decide independently. I had gone in a program, so I was just seeing the data. It's not that we are not doing the work. 80% of the cases being filed in court at different level are being decided within 3 years. There is some normal life also, as brother had shared, that on a day the case is filed, it is counted as an arrear. This is not the system. Arrear is if there is some abnormal delay in disposal of cases. If within 3 years we are deciding a case after it is filed at all levels, I have seen 80% plus cases. That's not that we are not doing anything. And another thing which was there, we have about 20,000 judges at different levels in the country. And about 2.25 or 30 crore cases are annually filed and decided. It's not a small work we are doing. But still, we always sit together, have these meetings, conferences, to see where we are lacking and where we need to improve with the same infrastructure. Addition of infrastructure, we all know it is lacking at many places. There are studies being carried out, little bit I'll share in one of the session also. But that is the most important part, that whatever is there, because when we joined service, we knew what are the facilities available. I think with the passage of time, these have increased manifold, and because of the intervention of the Supreme Court also, and the reports also, Shetty Commission's report, part, it was accepted in phases. But the fact remains that the infrastructure and facilities have improved with the passage of time in the last 15-20 years especially. We were lacking a lot of stenos and also the court staff also, courtrooms also. Now things have improved, so support staff is also good. Now what is the subject of this? The title is Docket Explosion and Exclusion. Explosion is there if you see the data, because we are deciding, like I said, to 80% cases, so 20% are going in backlog only. So that's why gradual increase in dependency is there, if you see the number wise only. But as far as exclusion is concerned, explosion is there. Exclusion is concerned, if you see the data, and I think it's our duty to visit the National Judicial Data Grid website. If you see that data, I was really surprised to see that about 70 or 69% cases are decided uncontested. It's really surprising. We need to analyze that. I asked the NIC people also that we need to go into detail of all this, that which are these categories of cases. Means these may be the cases which are either frivolous or should not have been entertained. So these can be excluded from the system at the very first stage. Maybe these are being settled also, we can't say. Exclusion is also, which is the forced exclusion. The people who can't come to the court, they are also by force excluded, those who should come to the court. And they sometimes use many other means to get their issues settled. As we know, a lot of civil litigation is being converted into criminal, because they want the fast disposal. The police involvement has increasing in the civil litigation. Recovery suit, they say 420. Specific performance 420. 138, they say 420 FIR also, because little different pressure is there. Then I had some non-bailable sections also, because 130 bail is there. So this is different kind of litigation, which I think we need to take care. Now ADR is one of the very important subject in this. And for that also, I think Mahatma Gandhi also initially said, I got a lot of satisfaction when I settled the cases instead of losing or winning in a court. Technology certainly is helping us, there is no doubt, because we all know that there was some study carried out that there is to be some standard load for the judicial officer. They said it should be normally 500 files, but I think nowhere in the country, except some remote areas. I have been in J&K, we had court at some places where the files were only 20-30, because we had to have the court there. It was remote areas. But I think throughout the country, you may not have any place where the files are up to 500 also. We have the places in the country, I've been in UP also, where the files are 20-30,000. The staff is 1+7, standard norm. So how those 7-person staff will take care of 20-30,000 files? Not manually possible. Processing of data means which type of cases, when listed, these, I'm not saying files can be taken care of by the IT, but this data processing and case management can very well be done with the use of technology, and is being done. If you see the technology being used, we have now huge amount of cases pending, like 5.20 crore cases at different levels, and most of them, majority, are at the district level only, 4.60 crore. So idea of these conferences is that our judicial officers should also share what problems they are facing and what ideas they have to take care of all these problems being faced by all of us, so that these can be taken care of. The training program is kind of a thing like some resource person comes here and he shares his knowledge. He is like throwing a ball to you. Unless we catch it, it's of no use, it will fall. So you have to grab that opportunity. And that learning should not be limited to you, because all of the judicial officers in a state or in a particular conference, like this is meant for 4 states, can't come to such programs. This knowledge, whatever you gain here, should be shared with your colleagues when you go back. Because one concept we know, that the knowledge always increases with sharing. So you have some idea, if you have discussion with your colleague, he may have some other ideas also on that. So this is how the knowledge will increase, and we will disseminate more information, more knowledge. And idea is not to make you cram things, and the idea of these conferences is also not that. The idea is that you learn how to distinguish between right and wrong, because that is our main job. A lot of people come, a lot of ideas come to the court, different type of facts and evidence is produced. You need to open your third eye to see who is right and who is wrong. Sometimes with the use of technology, this is also a little difficult. You see, we have evidence recorded on VC. The demeanor of witnesses is one of the important part, but that is missing now with this. With the use of technology, I think we need to be expert in that also to see how it is there. We can't ignore all this. The expression of a person while answering the question is very important. So technology is there, yes, and I think 2 days back I had seen that with the use of AI in some given facts story, a judge had created a video of that, because this is the software now available. Mr. Sachdeva will tell more, because he is up to date, means one step above. So I just saw in the news that he created the scene in a video of the given facts of a case, that how it all happened. But maybe this is the technology. Yes, it is going on. It will continue. Another challenge is your new criminal laws, because old will also apply, new will also apply. So there's a big challenge. Maybe there are some changes in some of the provisions. Section number is a different thing. So that challenge is there, and this challenge comes before the district courts first. You have to be very careful in dealing with those cases where the new law is to be applied, where old law is to be applied, and if there is a change in the language also. Judgment also, one issue was touched. Yes, our orders have to be speaking. But what we find is that sometimes in bail matters, you will find 30, 40, 50 pages written, which may not be required. You have 39 1 and 2 application decided, 30, 40 pages written. Not required. You have to be little precise. I am reminded of an argument raised by Mr. I think he was Ramaswamy, I think, senior advocate. He was arguing a matter at Chandigarh at one time. So we were just new entrant in the profession. He narrated a story that he wrote a letter to his friend saying that I am writing you a long letter because I don't have a time to write a short one. Because that needs time. You have to think over. You have to read 10 pages, then think over and make a précis of that and then write. If you are not tired, then you said you copy from here, and then the order is speaking 30, 40 page. Nobody will say it's a short order, nothing considered. But finally, consideration is 1 paragraph only. So you need to see that also. These are the few things, few thoughts I just wanted to share with you. I think you will have fruitful discussion in the 1.5 days conference, but be participative, I will request you, so that we have new ideas and those ideas can be implemented. Thank you. Jai Hind.
Highly obliged, Lordship. I will now request Honorable Mr. Justice A.Y. Kogje, Judge, Gujarat High Court and President, Gujarat State Judicial Academy, who has been the driving force behind our efforts to make this event happening, to extend a vote of thanks.
Good morning to all. Honorable Mr. Justice Rajesh Bindal, Judge, Supreme Court of India. Honorable Justice Manindra Mohan Shrivastava, Chief Justice, Rajasthan High Court. Honorable Justice Suresh Kumar Kait, Chief Justice, High Court of Madhya Pradesh. Honorable Mr. Justice Biren Vaishnav, Acting Chief Justice, High Court of Gujarat. Honorable Mr. Justice Aniruddha Bose, former Judge, Supreme Court of India and Director of National Judicial Academy. Sister and brother judges of the participating high courts, respected resources persons, judicial officers from the participating states, officers from National Judicial Academy, members of the Registry of the Gujarat State Judicial Academy, Shri Kamal Trivedi, Advocate General in absentia, Manisha Lav Kumar Shah, Additional Advocate General, Shri Mitesh Amin, Additional Advocate General, Shri Hardik Dave, Public Prosecutor, Shri Virk, Government Pleader. Ladies and gentlemen, good morning to all. With immense pleasure, I propose the vote of thanks on behalf of the High Court of Gujarat and Gujarat State Judicial Academy on the inaugural session of West Zone Regional Conference on Court Dockets, Exclusion and Exclusion under the Aegis of the National Judicial Academy. In the light of the principle of teach, train and share adopted by the National Judicial Academy, I thank the National Judicial Academy to give the opportunity to the Gujarat High Court and Gujarat State Judicial Academy to host the West Zone Regional Conference. I thank Honorable Mr. Justice Rajesh Bindal to be the part of the conference both in inaugural session as well as a resource person to a technical session. Justice Bindal is known for crisscrossing the nation for his interest in academics and application of information technology to the judiciary. I thank Honorable Mr. Justice Manindra Mohan Shrivastava for accepting our invitation to be part of the inaugural session as well as to be the resource person on an important subject in this conference. I thank Honorable Mr. Justice Suresh Kumar Kait to accept the invitation to be part of the inaugural session and to be with us throughout the conference. I thank Srimati Sunita Agarwal, Chief Justice of High Court of Gujarat, and my dear brother Acting Chief Justice Biren A. Vaishnav for reposing confidence in our academy and give the responsibility of this conference. I thank all the sister and brother judges of participating courts to be part of the conference and be here to share your valuable views on a very important issue. I also thank learned Additional Advocate General, Public Prosecutor and Government Pleader of the Gujarat High Court to have taken time to be part of the inaugural session. I thank judges from the participating judges for participating in full nomination strength to make the conference meaningful with their anticipated active participation. I must thank the Registry of the High Court of Gujarat for be deployed at full strength in making the event as comfortable as possible for all of us. I thank the Legal Department of the Gujarat State for accepting the proposal of the Academy to declare the judges of participating High Courts as state guests. I thank the officers of Gujarat State Judicial Academy who have worked tirelessly to rise to the expectation of this conference. Lastly, I must profusely thank the resource persons without whom the conference would not have been possible. I thank you all for being present and with an expectation that your stay will be comfortable. Thank you all. Jai Hind, Jai Jai Garvi Gujarat.
Thank you, my lord. The august gathering is requested to stand up at their respective places. Once the honorable dignitaries on the dais join them, we will have a group photograph in this hall itself, and thereafter we will be starting with our first session.